Good evening, everyone. My name is Michele Storms. My pronouns are she, her, and I'm the Executive Director at the ACLU of Washington. I'm speaking to you this evening from the traditional land of the first people of Seattle, the Coast Salish people who have stewarded this land for generations. Our office downtown sits on the unceded territory of the Duwamish people. We must always remember the role our country played in the stripping of the land, culture, and language of Indigenous people, including the horrific and painful legacy of residential boarding schools, about which we are continuing to learn more day by day. The tragic and uncalled for losses to Indigenous people have been extreme. They're a shame that we must deal with as a nation. Land acknowledgements like this are only a beginning. They aren't enough. We recognize there's much more work to be done to make this country truly fair and just, and to rectify past wrongs. Take a look at the chat box for information on concrete ways we can all support Indigenous communities into the future. And then join us for November's program, where we'll share more about Indigenous justice issues. So our Flights and Rights events are typically hosted in breweries and event spaces around the state, most often pre-COVID at the gathering space of KEXP 90.3 FM in Seattle. KEXP has been an important partner, and we're so grateful for their partnership. But even though we aren't together in person, we do have flights to go with your rights. And we have some interesting flights this month. If you're in the Seattle area, please visit Rojo Juice in the Pike Place Market. That's at Corner Produce, and mention the ACLU tab for $5 off today and tomorrow. There'll be more details in the chat box about the special cold pressed juices that will be available in honor of ACLU. And you can also find it on our website. We had a tab at Comadre Kombucha in Tacoma, and it's already been exhausted because you all are kombucha lovers. So thank you so much for your support. And please always support our partner organizations. We're so grateful for them. Also, you should know that everyone in attendance tonight has been entered into an ACLU of Washington Supreme swag giveaway. Our prize package includes Pride swag and a set of KEXP and ACLU koozies, something that you can't get anyplace else. Now, we'll draw names after the event and notify 3 lucky winners by email tomorrow. Okay, so to the business. We're here this evening to talk about our systemic equality agenda. Now, we cannot do our work without our allies, and by now you've seen lots of Flights and Rights, and we usually have partner organizations as speakers. But as we're announcing this ambitious agenda that the ACLU has taken on nationwide, tonight's panel is comprised of my ACLU of Washington colleagues. But do understand that all the work, even the work we talk about this evening, relies on us working in community with so many valued partners and friends. Okay. So why systemic equality? And bear with us because we're going to put up a few slides. It might take them a few minutes to get there, but I'm going to keep talking and they're going to catch up to me. Oops, they're catching up. Right on. Okay, so whoops, and then I lost my notes. Why systemic equality? One moment, please. I'm sorry, I completely lost my notes. Why systemic equality? Oh, so many good reasons. Just a moment. Okay, apologies for that. We have generations of Black, Indigenous, and people of color who've long been hurt by systemic inequality. So in other words, policies that directly and indirectly discriminate in jobs, education, housing, and policing. The ACLU believes we need systemic solutions to address systemic problems. So our state affiliate is launching Systemic Equality Washington, coinciding with the National ACLU's campaign. Through advocacy, legal action, and legislative work, we're addressing the nation's long history of systemic inequality, discrimination, and racism. So our statewide effort includes 3 pillars. The first is promoting justice and accountability. The second is strengthening community power. And the third is advancing equity. The first pillar acknowledges that we can't move forward with progress without first acknowledging the harm that's been done by past policies and actions and creating solutions that actually remedy those injustices, the pain they caused, and their lasting scars. Under this pillar, we're advocating for Congress to pass H.R. 40, a step toward reparations to acknowledge and resolve the effects of slavery, which are still felt today. We're also reimagining public safety to create a culture of accountability within policing and to prevent the type of police violence that has routinely impacted communities, particularly Black communities. We're fighting mass incarceration, which has been a harmful and costly problem in America in so many ways. We're working to expand and enforce the civil rights of immigrants, to disrupt Washington State's participation in federal immigration enforcement and deportation, and limit immigration and customs enforcement and Customs and Border Patrol's footprint in Washington State. We're also fighting to end the war on drugs, which is rooted in racism. We're working to disentangle school discipline and the criminal legal system to assure that when kids make mistakes, they can learn from them without the life-altering consequences of police and legal involvement. Okay, our second pillar. It's about strengthening community power. This includes taking down barriers to full participation in the democratic process, barriers that have long undermined Black and Brown voters' true political power. We'll say more about that tonight. We're also building power across the state, connecting grassroots activists with the information and tools they need to advocate efficiently and effectively for civil rights and civil liberties. Check out the chat box and learn more about how to join those efforts. Okay, our third pillar, is about advancing equity. We want to level the playing field to ensure everyone has access to the resources and tools they need to succeed. We're expanding healthcare access, especially in immigrant communities that have a high prevalence of uninsured and underinsured residents. The pandemic that we're still living under has highlighted long-standing disparities in healthcare access and outcomes. Many Black, Brown, and Indigenous communities continue to work as essential workers while often being denied public benefits because of their immigration status or inability to secure quality, affordable healthcare coverage. We're addressing Washington's housing crisis, which is fueled by racist housing laws and practices, zoning issues, and continued in part through the criminalization of poverty. We're also working to prevent artificial intelligence discrimination. Algorithms are shaping every part of our society and are often created and used without transparency and accountability. Because algorithms reflect and perpetuate human biases, they often discriminate and cause harm, exacerbating systemic inequities across many sectors, including in education, healthcare, housing, and our criminal legal system. Access to technology itself is a whole other issue. We're working to extend tribal broadband access. In many Indigenous communities across Washington, internet access is slow, unreliable, or unavailable. Internet access is a basic necessity at this point in our lives, and its inequitable connectivity cuts families and communities off from employment opportunities, education, healthcare, and everyday needs. Lastly, we advance equity by investing in our communities. Our growing Civics Day program brings critical Know Your Rights information to high school students. We also regularly sponsor discounts and giveaways at Black, Indigenous, people of color, and LGBTQIA+ owned businesses. And we distribute Know Your Rights resources all around the state. It's a lot, we're on it. And with that, I'm excited to introduce some of the ACLU staff who work on the front lines, who are going to dive way more deeply into some of the issues that I've touched on. So let me tell you who they are, and then we're just going to get right into it. So first, popular return speaker, Enoka Herat. Enoka is our Police Practices and Immigration Counsel here at the ACLU of Washington, known as our first resistance hire during the former Trump years. She has come in to expand and enforce the civil rights of immigrants and to ensure local law enforcement does not aid any administration's agenda of mass deportations, any partisan agenda, doesn't matter which side. Enoka joined us in 2017 in direct response to the Trump administration's attacks on immigrant rights. She previously worked at the Washington Defender Association's immigration project, where she supported public defenders in navigating the immigration consequences of criminal offenses. Enoka graduated from the University of Washington Law School and served as a judicial law clerk at the Seattle Immigration Court for 2 years, the Department of Justice's honors program. A former president of the South Asian Bar Association of Washington, currently on the board of One America, and the child of Sri Lankan immigrants living in Beacon Hill with her husband and 2 incredibly adorable children. Okay, next I'm thrilled to introduce our senior staff attorney, Antoinette Tony Davis. First time here at a Flights and Rights. Welcome, Tony. She is homegrown Seattle. Known by Tony, she graduated from the University of Washington, Go Huskies, and Seattle University School of Law. After graduating from law school, Tony clerked for the Honorable Justice Tom Chambers of the Washington State Supreme Court, and later went on to practice civil rights, bankruptcy, and consumer rights before joining the ACLU of Washington as a senior staff attorney. Tony is dedicated to the community in which she grew up. She's currently on the board of directors of the National Alliance on Mental Illness and is a mentor to many, particularly attorneys of color. Welcome to Flights and Rights, Tony. And rounding out tonight's group is another favorite back again at Flights and Rights, Jaime Hawk. Jaime is our legal strategy director for Smart Justice, and her job is to reduce over-incarceration and reform the criminal justice system through legal and policy strategies. A major focus of her work is reforming our state's pretrial detention system, which keeps people locked up simply because they lack the money to pay bail. Jaime's passion for reform was shaped by nearly a decade's work helping clients through the criminal justice system as a state and federal defender. Jaime began her legal career working on immigration and civil rights as a fellow at the U.S. Senate Judiciary Committee staff of Ted Kennedy. She continued her work in criminal justice at the Administrative Office of U.S. Courts in D.C. as a legal observer to the military tribunal proceedings in Guantanamo Bay. Jaime serves on the National Council of the American Bar Association Criminal Justice Section and the Washington State Bar Association Council on Public Defense. A graduate of Gonzaga University School of Law, Jaime is an enthusiastic fan of Zags basketball and loves to travel. So those are my wonderful colleagues that I'm so excited to share with you this evening. And I'm going to get right into it, starting with policing. So policing is an area with an intensely racialized history that continues to play out in current events. Too many killings of Black and brown people by police. Enoka, could you talk about our policing work and how it fits into this concept of systemic equality?
Sure, Michelle, thank you for having me here. Policing is a great place to talk about the systemic inequality that we are seeing and we're trying to change. For most of the history of America, policing has really been a tool of social control. The origins of policing, as we know it, really came from slave patrols and controlling, enforcing racist white supremacist laws and controlling the Black population in America. Policing has been used to control labor movements, the houseless population. It's been used as a tool to try to address issues around health inequity and inequality, around addictions, et cetera, et cetera, et cetera. And I think actually a lot of law enforcement also agree that police should not be the solution to these issues that we are seeing. One approach we do take around policing is that the issues, the violence that is caused by policing are not due to individual sort of failures within the system. It's not a bad apple here and there, but actually there's something about the system of policing that causes these outcomes because of the focus that our society has on penalizing, on controlling different populations. And so as we approach policing, we have those ideas in mind. And I'd say some of the main ways that we try to address policing in Washington State is, number one, to reduce the role of police, to get police out of doing things like addressing, being the go-to response to people in crisis, to reduce the role of police in terms of decriminalizing things so that there is less conduct that needs to be met with the penalties of the criminal system, particularly since law enforcement are gatekeepers to the criminal legal system and everything that entails. The more we can do to remove police from that equation, sort of the better outcomes we can see in a number of different arenas. Another bucket of our work is to reduce the scope of police and the powers of police. And so lawmakers, again, just historically have given police so much power, and they are authorized to use force, to use deadly force against us, to not only take life, but also to take liberty. And so reducing their power to do those things, reducing their ability to use force against members of the public, that is critical, again, to reducing violence across our state. Another element, sort of bucket of our work, is reducing resources to law enforcement. They have been given so many resources in order to solve these problems that they don't have expertise in solving. And so removing some of those resources from law enforcement and instead investing in housing and education and healthcare and mental health services, giving people opportunities. I was just talking to a law enforcement officer yesterday who said, if someone is calling us in crisis, the system has already failed them. And I completely agree. There's so much we need to do to invest upstream so that we don't need to call on police, armed police especially, to respond. And then I think the last pillar of our work around policing is expanding the rights and strengthening community power. So expanding the rights of those who've been over-policed and those who've been harmed by police so that they can hold officers accountable and they can hold departments accountable and call for change. So those are some of the tools we're using and approaches we're taking to address this systemic inequality. And I'm happy to give examples of sort of what some of that looks like in practice, but I'll pass it to Michele.
Well, no, and that's fine. And what I'd love is maybe just take one of our, because we do this work, a lot of it through the legislative system, and we also do it in close relationship with community partners, people who are directly impacted by police violence. And I would love if you would maybe pick one of the bills that we passed last year and say a little bit more about it and how it really is an example of moving forward on an agenda of creating systemic equality.
Sure. So we work very closely with the Washington Coalition of Police Accountability, and that is a coalition that really centers the voices of people who've been impacted by police violence. So it's a lot of family members who've lost loved ones to police, and they really drove the agenda and drove the priorities. Were at every single lawmaker meeting, testified on the bills, really sort of poured their hearts into it, so that other families don't have to suffer the way they have. And Michelle's right that we do a lot of work in the policing arena with state legislation, and that is in part because it is actually difficult to sue police and have sort of systemic change, because the ways that the laws are set up, it really is set up to go after sort of individual officers rather than sort of creating systemic change within a department. And we haven't always had the ability to use state legislation. An example I give is in the 2019 legislative session, there was a couple bills around policing. One was around collecting a little bit of data around racial disparities in the use of force, and it didn't even get a hearing. And so this year, having passed 12 bills around policing, it really was such a stark contrast, and there's so much more opportunity this year. And that would not have happened if it was not for the uprisings and the protests that happened last summer. So people, showing up the way they did really pushed lawmakers to make some change. And I think the bill that we're the most proud of, and these bills went into effect this past Sunday, July 25th, is the use of force bill. And so what this does is it restricts when police can use force, physical force against someone, and how they use that force. And so one thing that was really important to the family members is just this baseline idea that police can't use force against someone if they're just if they're not even committing a crime, if they're just being. And so there are so many instances where someone was literally just walking down the street and police officers assumed the worst about them, assumed they were some sort of suspect or involved in some suspect activities when they weren't at all, and they were killed because of it. And so, some of the names you may have heard of is John T. Williams, Manny Ellis in Tacoma recently, Stonechild Chiefstick on the peninsula, who was at a 4th of July party and had a screwdriver in his pocket. Tommy Lay, who again was holding a pen, and officers thought that was a gun. You know, there's so many more examples, and all those families are part of this coalition, saying, you know, enough is enough. You know, we have to put limits. We can't allow police officers to just use force whenever they feel like they can or they should. And so that was a first limit, saying, no, you can only really use force if there's probable cause that someone's actually engaged in criminal activity, or if there's an imminent threat. It also put a limit on when deadly force can be used. Right now, there really sort of isn't that limit. It's based on what is reasonable to the officer from the officer's perspective. And now, because of this law, officers can only use deadly force when necessary to protect life, to protect either the officers, the person in question, or a bystander's life. And that seems like such a basic, I think most people assume that has always been the standard, but it hasn't. And so all these things are a step forward and a step in the right direction. And we're already seeing some of it working. The number of people who've been killed by police officers has tapered off since April, when session was sort of ongoing. And that is significant. I mean, historically in Washington State, we've seen officers kill between 30 and 40 people a year. And this year so far, there's only been 10 or 11 people who've been killed. Not to say that that is okay at all, but already we can see that there is some hesitation to use force, and that is the law working. And police officers have been pushing back against that for the past week. They've been throwing a fit about these laws, doing a major press campaign to say, oh, this is making us all less safe. We're not allowed to show up with the kind of force we'd like to. But ultimately, that these laws are protecting the civil rights and civil liberties of Washingtonians.
I really appreciate everything that you just said, Enoka, and on that very last point that you just made about sort of the law enforcement pushback about the use of force law. One of our recent blog posts in our policing blog series addresses that. And sets the record straight on what that law actually says. And so I know we'll get a link in the chat box for those who have not seen the policing blog series. It is something I'm extraordinarily proud of. There's a lot of really useful and helpful just examination of what policing is, and where the trajectory it's been going in, and really giving some commentary and feedback on that. So please check that out if you have the chance. I also appreciate that you mentioned, Enoka, sort of the policing as a gateway right into our criminal legal system. And that gives me the chance to turn my attention to Jaime, because we have an entire system of mass incarceration that disproportionately impacts Black people and other people of color. And I'm wondering, Jaime, what you've learned about sentencing relative to systemic equality conversation, and what does the advocacy look like to make change in that space?
Well, thanks so much, Michele. It's really great to see everyone and be with everyone this evening. And thanks to all of you who are tuning in and joining us for this conversation, and of course all you do to participate and support our work. So yeah, just to spend a couple of minutes thinking about our current state of mass incarceration, and particularly one of our top priorities when we think about both litigation and legislative advocacy and forms of reform is sentencing, and really looking at the prison population. And as Enoka just discussed, racial bias permeates throughout our criminal legal system, and it starts in policing, of course, that initial contact with the system, and then all the way through arrest and pretrial detention, the use of money bail, holding folks in jail, and all the way through to sentencing and prison. And so in Washington, when we look at our prison population, we know that racial disparities are very stark nationwide, but here in Washington, African Americans are 3.5 to 4% of the state population. And when we look inside our prisons, close to 28% of people sentenced to life are Black. And our 18% of the overall prison population is Black. So when we think about systemic equality, dismantling mass incarceration, our strategies through our Smart Justice campaign and more broadly are to, of course, shrink our jail and prison population as much as possible, but that's not enough. And we have to be actively looking at racial disparities and disproportionality and actively thinking about strategies to ensure that they're also shrinking and kind of, what that can look like. So one of the things I wanted to quickly highlight is right as the pandemic was hitting last year, we had been partnering the previous couple of years with Dr. Catherine Beckett and Dr. Heather Evans at University of Washington. And so we rolled out this very lengthy report with a shorter executive summary that's easier to take a look at. We'll put a link in the chat for anyone who might be interested if you haven't had a chance to look at it, but it's 30 years of data. And the data, of course, is so important to really expose the racism and the racial disparities so that we can really get serious about strategies to tackle it. So we released this report in partnership with the professors and just really showed how increasing life and long sentences are driving mass incarceration in Washington state. And then we worked and partnered with individuals who are currently incarcerated. We interviewed several folks and to share stories of transformation and to really put a spotlight on several incredible individuals who deserve to be released. And then we really put our heads together and collaborated around what the recommendations should be and how to implement legal and policy strategies and what they want to prioritize. So it was a real collaboration and partnership, and we got the report out. And of course, again, I won't bore you with too many statistics, but it just really breaks down how sentences are getting longer and longer. Our prison population is aging. More than 1 in 7 prisoners in Washington is over 50 years old. And most folks don't realize, we don't have meaningful parole in Washington. So folks are going to die if we don't take action and start changing the laws. So, when it comes to sentencing, we are very active with lots of amicus briefs and a range of cases around particularly life and long sentences, and particularly folks who were young at the time. So looking at life without parole, folks who are kind of under 18 or kind of that emerging adult 18 to 25 age. So we've been really trying to advance the law and get relief and partner with lots of other attorneys and advocates to really advance the law in some critical ways there. But also fundamentally, to really dismantle mass incarceration, we have to change the laws. So that is legislative advocacy. And so just to highlight a couple bills, so we have a large, robust coalition of lots of organizations, family members that we work really closely with, and then of course, really centering the voices of men and women currently incarcerated and what they think the most important strategies are will have the biggest impact for the most number of people in prison. And so just a few bills that are still alive that got introduced this legislative session that we're continuing to work on into 2022, and really are hopeful that some may pass. But one top bill is around what is commonly referred to as good time. So earned release time. So how much good time a person can earn while they're serving a really long sentence. And so there's legislation sponsored by Representative Simmons that will increase good time to 1/3 for everyone. And that would have significant impacts on racial disparities over the next decade or so if that bill could pass. And then we also have a couple pieces of legislation that, again, really kind of looking at that emerging adult population particularly when we look at racial disparities and the numbers of young men, Black and brown men who were arrested and prosecuted at young ages and who are now serving really lengthy sentences. There's a bill we're calling the Emerging Adult Bill that would give them an opportunity to show their rehabilitation and transformation and hopefully get resentenced and have an opportunity for a shorter sentence. And then thirdly, there's a bill that we're referring to as juvenile points. And currently what many folks don't realize is that when you go through the juvenile system or you're declined and you're prosecuted as an adult, but you were young, under 18 at the time, those convictions or adjudications can be scored for adult purposes. And so we want to make it so that what happened as a juvenile, that those adjudications are no longer calculated into someone's sentence, which if we can make that retroactive, and that's the key part, to really bring folks home who are currently incarcerated in prison, these laws, the legislature needs to make them retroactive so that people inside have an opportunity to be resentenced. So those, and there's a number of particularly men and some women of color who would benefit immensely from these changes in the law. So those are just a few of the priorities that we're working on now.
Thanks so much, Jaime. And I really appreciate all of that. And I just want to highlight two things, right? One is, and this is made very clear in the report, and the link is in the chat there. So many of the people with long sentences were sentenced at ages 16, 17, 15 years old. We know from brain science that this is at a time when a person's judgment has not fully developed. And we also know from social conditions that oftentimes people are in situations in which it's easy to go down a wrong path and be in a place to make some wrong decisions. But then what we do is we literally punish them for the rest of their natural life. And it's devastating. It's devastating. And then I think the other thing I just want to accent in what you said, Jaime, so beautifully, is that because, and this flows back to what Enoka said, because we over-police Black and brown communities, that is where the police are showing up. So despite the fact that those may be smaller percentages of the population, they're overrepresented in the criminal legal system. And this is something that we truly have to interrupt. And that is why way too many people, Black and brown folks, are really wasting away in prison without any regard for what they've learned, how they've grown, and what they've changed. And that sentencing report really highlights that quite beautifully with lots of personal stories as well as statistics. I want to get to Toni, because I know you're all anxious to meet her, but I want to quickly, there's a couple of questions coming in, and one of them I want to just jump on right away because Enoka, it relates to what you referenced a moment ago about the sort of law enforcement media campaign, right, about this use of force bill. And the question is, what else are we doing in response to that to try to set the record straight? And I think you might have a couple of things you can say about that. And then I'm going to get to Toni. And I see other questions too. We'll come to those later.
Sure. I mean, we think that there has been a coordinated effort, probably through the Washington sheriffs and police chiefs, which is a sort of association that was pushing back on the laws during session 2. And what we can do is continue to put in good information out into the public sphere and keep pushing for public education on this. We're also meeting with a lot of different law enforcement groups. I was just meeting with some sheriff's deputies in King County and meeting with someone from Vancouver tomorrow. And, I think a part of it, I think one thing to note is that there has not been any lawsuits to enjoin the laws from going into effect. A lot of it is sort of PR bluster. And so, where there are places that could be clarified in the law, I think there's sort of another question that sort of touches on that. The Attorney General's office has been tasked with providing guidance on implementation, and that'll be available next year in July. But in the meantime, I think there is quite a difference between law enforcement coming to the table and trying to figure out how to make things work, and sort of picking and choosing where they're interpreting things really narrowly or really broadly to just sort of try to blow the whole thing up. And there are a lot of law enforcement agencies that are doing the right thing and saying, we've been trained on these tactics. We have our own definitions of use of force. None of this stuff is new, and we're going to just keep following the law. So to me, it feels very more political than actually sort of issues with a lot of the policy at play here. But yeah, we're doing what we can to put op-eds across the state, and working again, and the coalition is really driving this too, to sort of just be talking to media and putting statements out so that we can sort of clear the air and put as much real information about these laws out as possible.
So because there was a question that referenced, the sort of what may be a lack of clarity about definition, is that of use of force, and that being one of the things that law enforcement is hanging their hat on. Were you saying that that's what the Attorney General's office is working on?
Yes, I mean, the definition of what constitutes physical force is, that is, every single agency has some definition. That's what they train on. The Criminal Justice Training Center, which is Washington State sort of police academy that does all the training for Washington State officers. These are not ambiguous terms. Like, these are terms that are terms that have been in use with law enforcement. There were some concerns about, there have been other sort of quibbles with language and sort of requests for clarity. And I think that it's possible that lawmakers would consider clarifying some of those things if necessary. But in the meantime, I think the Attorney General's office is looking into it. And again, it is true that some law enforcement agencies are taking their own interpretations of it. But another place, for example, is they say, oh, well, we can't respond to mental health calls. But that is so very clearly a choice they're making, and there's nothing in the law prohibiting them from doing that. And so, that's just an example where that doesn't really require clarity in the law. It's just they are interpreting it in a way that doesn't actually make sense. And they're making a choice and blaming the law for the choice they're making, rather than actually just following the law itself. And, some of this is growing pains. Like, it is a change. That was a whole idea. This is a systemic change for something that has been embedded in police culture for, since the beginning of our state, right? So, and there will be growing pains, and there is a lot of fear, I think, in law enforcement right now around these laws. But the policy is strong. The policy is based on best practices. None of it is really a big surprise to law enforcement. A lot of it mirrors existing policy and definitely existing training. And so putting it into state law is the best thing to do, so that there is sort of a statewide standard on these things. And the Criminal Justice Training Center will train to it, et cetera. So I think a lot of it right now is some of that growing pains and some of that political sort of backlash that was really sort of predictable.
Sure. Well, thank you for clarifying that. And I appreciate your reference also to the fact that, many law enforcement agencies are embracing this and trying to figure out how to make it work. At the end of the day, right, the driving force of this is the sanctity of life, right? The idea that we want to be more mindful of when force is used, particularly deadly force. And at the end of the day, we do want all of our communities to be safe. And by that, we mean all of our communities to be safe, right? Okay, so somewhere in between policing and sentencing is the courts, right? And the courts are a part of our systemic equality agenda as well. And so this is where I am turning to you, Tony, and asking you to talk about some of the issues of court access and ways in which we are addressing systemic equality in the way that courts function and run, whether it's various barriers, whether it's jury issues. You have the floor to take it wherever you would like to take it.
Thank you, Michelle. And good evening, everyone. It's a pleasure to be here. So there are, as Michelle mentioned, various barriers to accessing justice, accessing the court. And the ACLU has done quite a bit of advocacy around a few areas, one of which is financial barriers, right? Fees, fees, fees. There's jury fees, there's filing fees, there's copying fees, and in some instances, interpreter and translation fees. And that's just a few of many. And while waivers can, in some instances, be obtained for filing fees, one would have to know how to navigate that system, how to file a motion to waive the fees, what to ask for, how to get it in front of the court. It's a barrier for many people within the community. There's numerous physical barriers that make appearing in court also difficult. Attendance in court requires planning, it requires resources, things that some people don't have to think about. Black, brown, and indigenous communities routinely have to think about, including, taking into consideration transportation, how to get to and from. There may also be conflicts with, being sick or with work, school, childcare, family, and other personal obligations. And particularly because the court hours are during core work hours. So not only are there financial barriers, but there are physical limitations. In addition, technology can also be a barrier. Many courts across the state have switched from in-person filing to electronic filing. I don't know how to use all of the filing systems, right? But many people find those types of systems difficult to navigate. As well as there are folks who just simply don't have the financial means to purchase the equipment necessary, right? A computer, a printer, or to buy the necessary software that they need. And then finally, one area where there's a barrier is in jury service. I don't know how many of you have had jury duty, but you don't get paid much, do you? So, and it's well documented, by the way, that there is race bias in the jury process. And some of those disparities show up in who's summoned to be a juror and who appears to be a juror. Adequate payment, is really important. But that also doesn't take into consideration the expenses that people also incur. For example, childcare and travel expenses that you might incur in order to fulfill your jury duty. But I have three other examples that I want to share that also feed into the jury system itself and how it has an impact, or how systemic inequities have had an impact. The first one is GR 37, or General Court Rule 37, which is intended to eliminate racial and ethnic bias in the jury selection process. I want to read for you a quick quote that was actually shared earlier today by Lila Silverstein. And I was inspired by it. And so I looked it up, and it's actually a quote by Brian A. Stevenson, that reads, "There is perhaps no arena of public life or governmental administration where racial discrimination is more widespread, apparent, and seemingly tolerated than in the selection of juries." And that's a powerful statement, right? But juries hold a lot of power. And one way that that has shown up was with respect to peremptory challenges in the jury selection process. A peremptory challenge is the right to challenge a potential jury without assigning or being required to assign a reason for that challenge. And what attorneys in the community were seeing was that there were clear but not so clear implications of race bias in jury selection, right? Focus on attitudinal issues, those things that are grounded in stereotypes without actually explicitly saying it's because you're Black, right? Or it's because you're Native and we don't trust you. So before GR 37, there was some protection, but it was limited to those things that are considered purposeful discrimination. It is difficult to prove purposeful discrimination because it doesn't often happen, right? It's discrimination, purposeful discrimination is something that is more easy to prove. But it's the implicit biases that were being ignored, those stereotyping attitudes. So before GR 37, the standard was purposeful discrimination, and it failed to address the unintentional, institutional, or unconscious bias that attorneys were seeing with peremptory challenges. So in response, the ACLU formed a committee and started discussing racial and ethnic bias in jury selection. And as a result of that committee work, and I believe it took a couple of years for this to happen, but they ended up proposing, or we ended up proposing GR 37 to the Washington State Supreme Court, or what would become GR 37. And I think one of the critical pieces of the work around this was as a part of the process for explaining why GR 37 was needed. Numerous stakeholders, including the ACLU, provided comments. There was a lot of research, proposed language that was offered addressing harms from juror discrimination at the jury selection stage. And what resulted intrinsically from that was evidence of harm, right? That it was intrinsically harmful race discrimination that was occurring at that stage. But it wasn't just the harm that was lifted up, right? The impact of not having a diverse jury, but also the importance of having diverse juries that contain Black, Brown, Indigenous people. Because research shows that racial diversity within a jury actually improves the quality of the decision through the process of information exchange and leveraging that, through different lenses. And ultimately, obviously, the Washington State Supreme Court ended up adopting GR 37. And it was to address implicit bias, but the court also approved a different standard, which was an objective observer standard, but it was the way in which they defined objective observer, and that being one who is aware of implicit, institutional, unconscious bias and purposeful discrimination. So taking those two elements and marrying them together. We've also challenged race bias that occurs during a jury deliberation. There's a case, State versus Bury. In this case, a Black juror was accused during jury deliberations by fellow jurors of being sympathetic to the Black defendant because of their race. She was also subject to a barrage of harassing comments about rap music and the like. And finally, worn down by race comments that were directed by her, when it came down to vote for whether or not to convict the defendant, she simply relented and voted to convict. The next day, she regretted having done so and made the court aware. The problem was that the court didn't do a meaningful inquiry into whether or not this race bias occurred and whether or not it impacted the ultimate decision. With all of that said, and I'll cut it short, we submitted an amicus brief along with other folks in the community. And the state Supreme Court recognized when allegations of jury misconduct arise, that the trial court does have discretion as to whether or not an evidentiary hearing is necessary. However, the court also found that there are limits to that discretion, that particularly in cases of alleged race bias that deprives a defendant of his or her constitutional rights to a fair trial by an impartial jury. After the court sent that decision back down to the trial court went through the process of doing what it should have done from the beginning, which is to have a hearing on the record in open court, calling the jurors and calling the impacted juror herself. And what resulted from that was a new trial because the court concluded it in fair was not a fair and impartial, a fair and impartial trial.
Thank you, Tony. It's exciting, some of the work that we've been able to do in that space. And I think one of the things that I make note of when you were just talking about barriers, all the things related to court hours, transportation, childcare, everything, you know, when we devise systems that work well for people who are in the most marginalized and vulnerable conditions, we actually make it better for everybody. And if we could see it in that way, a systemic equality agenda that is arranged around addressing past harms, perhaps facing Black and Indigenous and other people of color, actually ends up being a system that benefits everyone, regardless of how they're situated. And that's what I think is so important about this work. Once again, my friends, we have so much to say and never enough time in which to say it. So there's only one more thing. I had like 5 more things I wanted us to talk about, but there's one more thing that I want to make sure that we talk about, because I do feel like we'd be remiss in a systemic equality conversation to not address issues of voting. And while it is certainly the case that around the country, particularly in southern states, the things that are happening with regard to voting are really just about keeping huge swaths of people from being able to vote, particularly Black people, low-income people, other people of color. In our state, some of our advocacy has really looked like the rights of people who have been formerly incarcerated. We had a lovely victory. And so I think the last thing that I want us to talk about, and that we'll end on, if Jaime, you could talk about the voting rights issue that we just dealt with recently.
Thanks so much, Michele. Yes, one of our top racial justice and criminal justice bills that we've been working on for a few years now that passed the legislature is a bill on voting rights restoration. And so this new law is going to go into effect on January 1st of 2022. So there's about over 20,000 people who are currently on DOC community custody, who are in our communities, released from prison, and their right to vote will be automatically restored on January 1st. So they will have to get re-registered and request their ballots, but it's a really, really exciting victory. And when we think about structural racism and laws that are on the books now upholding structural racism, felony disenfranchisement is truly one of the laws at the top of the list. And there should be no connection between someone's criminal history and their fundamental constitutional right to vote. So we're very excited about this victory, but there's a lot of work ahead to join the only 2 other states in the union that allow folks in prison to vote as well, to completely dismantle and separate the connection between the right to vote and any criminal history. And as well, we're also doing a lot of work now to improve voting access inside jails. So but very, very excited, proud of our legislature, and please would really appreciate the help from all of you to spread the word that the law will be changing on January 1st. We'll be updating our Know Your Rights materials on our website in many different languages and things. So please reach out if you have any questions or there's anything we can do to help implement the law and reach as many people as possible.
That's fantastic. So, kudos, as you said, to the legislature for really taking that bold, but honestly, completely logical and appropriate move in passing that law, and gratitude to a really wide coalition of lawyers and community partners and regular folks who really fought for this. And, part of what our mass incarceration system does is it's like it never stops punishing. It's like punishment after punishment after punishment, right? And the idea, the idea that that it's so hard to be able to vote again, when in fact, the more we have social science that tells us, the more that you can be engaged in your community, the more likely you are to be on a safe path, being engaged with, employed, having a place to live, voting. Instead, what our system often does is practically push people into situations where they don't have options because they can't find a job, they can't find a place to live, they can't really engage with the community. So I'm really excited for any of the changes that we're able to be a part of that help us to get there. So we're out of time. I'm sorry we didn't get to hear more from you all about many other of the issues that we are thinking about in terms of systemic equality, with bail reform, immigration issues, our work in the child welfare system where there's systemic racism as well. So all of you just know that that is work we're doing. We'll continue to share more with you about it over time in various different ways. But this was just this opportunity to let you know about a broader campaign in a way that we're thinking about a body of work that we're doing. So thank you so much, Enoka, Tony, and Jaime. All of you are just doing brilliant work. It's always so appreciate hearing from you. I know our audience appreciates hearing from you. So everyone, hey, in August, we're taking a break. There will not be a Flights and Rights in August, but save the date for our next one, which will be about drug decriminalization in September. It'll be on September 28th. So please save the date and be ready for that. Speaking of systemic equality, the war on drugs, its roots are squarely in racism, and the way it has played out over many decades is exactly racially disproportionate. And so it's an important conversation. We're really looking forward to sharing that with you. So for those of you who are in Seattle or close to it and can get to the market, please go visit our Good Buddy Row at Rojo Juices. The juices are so delicious, you all. And so I'm excited for us to be able to partner. So from all of us at the ACLU to all of you in solidarity, thank you so much for your support, for being here. Have a wonderful evening.